Gentlemen, today we are going to be looking at the topic evidence. So, we are going to trace a couple of topics under the law of evidence. But first of all, we want to define the word evidence. That somebody asks you what is evidence, what is the meaning of evidence. When somebody talks about show me evidence, what is the person actually talking about? So when we talk about evidence, we can understand the word evidence from two perspectives. The first one is the common person's view, that is the ordinary perception of what the meaning of evidence is, while the second aspect of the meaning of evidence is what we call the legal meaning of evidence. Now, ordinarily, if somebody comes telling you, I've not eaten, I'm hungry, and you're looking at the person maybe in disbelief, you don't believe that this person is hungry, you could let's also check inside, for instance, that this person who is telling you that he has not eaten has toothpick in his mouth. And the impression you have is that there's no way this person can be telling me he has not eaten when he has toothpick in his mouth. So as far as you're concerned, the toothpick in the mouth of your friend signifies the fact that he has eaten something. So you can ask him, if you say you have not eaten, why do you have toothpick in your mouth? In other words, you are disbelieving him. You are saying something that creates the impression in your mind that this person has eaten food. And what is that you have seen? In the common sense, it is called evidence. You have seen an evidence showing that this man has eaten something. You have seen something, a symbolism that replicates the fact that this man might have eaten something. The same thing can also happen if maybe you see dent, maybe let's say student around the man's mouth or his clothes, and he said, my friend, you're telling me you have not eaten. How comes your clothes are smeared with soup or stew? In other words, what you are saying as evidence which conflicts what your friend is telling you is the evidence that he has eaten food and that he is lying to you. So the lesson to drive home from here now is that when you talk about the ordinary man's perception of the word evidence, it can simply be a subjective thing. It's a subjective test. So what amounts to evidence in the eyes or in the mind of one person may, as a matter of fact, not amount to evidence in the eyes or in the mind of another person. It could be that this person with toothpick in his mouth has the habit of putting toothpick in his mouth. It could be that the cloth that is besmeared with silk was something that was done some time ago and he picked his clothes, wore it without noticing the stain on his shirt. So for him, what you think is evidence that he has eaten is no evidence at all. This is the subjective approach to the word evidence, which means what amounts to evidence to me may not amount to evidence where you are. What then is the ordinary meaning of evidence? It simply means something that shows proof of a particular thing, something that establishes a fact. It could be an establishment of a point in issue, a point of an argument. The point of argument here is whether our friend has eaten or not. And I have seen something in my eyes as a layman that establishes the fact that this man has eaten. But my evidence may be faulty. That is where evidence in the common sense works. Then the next we have to look at, what then is evidence, judicial evidence or legal evidence? Legal evidence or judicial evidence has been severally defined. We are going to consider opinions or views of some scholars to know what they construed or what they perceived as evidence in their own opinion. So I will start by talking about our own Aguda. Aguda's definition of the word evidence can be summarized in this manner. Evidence is the act of proving a fact in issue either orally, documentarily, or by real evidence, but excluding inferences. But excluding inferences. So when we look at Aguda's definition of the word evidence, you notice something that is strikingly similar to the ordinary man's perspective of the word evidence. What is it? Something, proving something. But when you look at Aguda's own, he has anchored his own to the fact that that something is out to prove or disprove a fact in issue. Is out to prove or disprove a fact in issue. I also discovered that his definition of the word evidence has also brought to bear the explanation or the introduction of some types of legal evidence. For instance, he said it may be orally, so which means if I'm adducing evidence, it could just be verbal, say me talking to you or talking to the court. Oral evidence is one of the methods of adducing evidence. Or he said, and he also said, or documentarily. So I can tender a document to prove my age, maybe my birth certificate or an affidavit declaration of age. I can also tender a document, maybe my certificate, to show that I'm a graduate of University of Lagos. That's documentary. And then he also said that another form of proving evidence may be by real evidence. When we talk about real evidence, it doesn't mean that anyone is fake. He's simply meaning that evidence that's immovable. For instance, if it is an issue, a fact in issue, as to when Mr. A died, and nobody is able to adduce a credible evidence, a credible fact to tell us the exact time that Mr. A died. There could be this information that when Mr. A died, he was buried and an epitaph was raised. And then we can say, okay, let's go to that place he was buried. Let's see if something is written. So maybe when we get there, we see Mr. A lived from 1959 to 1987 or to 2023. Right. That alone has given us an evidence. And that evidence is contained where? On a substance. And which means this evidence rests on a substance that is immovable. Because there's no way you can move somebody's grave to the court. So that is called real evidence. Again, to I give you another example of real evidence. Let's say, for instance, we have a land in dispute. And someone is saying, I know the land very well, when it's attempted to tell us the boundaries of this land. And then, and also say there is an Iroko tree standing at the center of the land. You can't move that Iroko tree to the court. Neither can you move the land entirely to the court for the court to see the land and see the Iroko tree. Right. In other words, what is he trying to adduce? Real evidence. So the best way for you to determine whether an Iroko tree exists at the center of this land is to do what? Make an application to move the court to the locus in court. The court moves to the land, makes observations. That observation, maybe the court goes there and see actually there's an Iroko tree. That Iroko tree now constitutes what? A real evidence. Good. So when you look at Aguda's definition, to all intents and purposes, you say, oh, beautiful, this is good. It covers what actually a judicial evidence should be. But then there's a problem, which is definition. What is the problem? In his definition, he has said excluding inferences. Inferences simply means that thing you will look at and use common sense to say, If this woman has a protruded stomach, then that means she's pregnant. The fact that you are inferring, saying that she's pregnant, basically because you have seen her stomach protruding, is what is inference. So when you look at even the evidence act, you discover that there are so many instances of presumptions and inferences. Professor Cockle defined evidence as a means by which a fact is proved or established to the satisfaction of the party inquiring, and so long as that evidence is credible. So when you look at this definition, you discover that he's still talking about proving a fact, right? And he has introduced something, but also omitted other things. He didn't bother to tell us the mean or the arms of evidence, like how can we abuse evidence, just like Prof. Aguda said, but he didn't try to delve into that. He simply said it means by which a fact is proven or made evident to the satisfaction of the person inquiring, so long as that evidence is credible. So two major things here: the evidence must be credible, and then it has to be to the satisfaction of the person inquiring. So men looking at it from the face value, we say, oh, this is a fantastic definition. But I tell you something that is wrong here, and that is you're talking about making the evidence credible and at the same time satisfying the mind of the inquirer. Right. You may satisfy the mind of the inquirer with evidence that are not credible, that the fact that are not true. Under law, we call that misleading facts. Why? Because the person inquiring doesn't know. He just simply believes in you, and if in the end you have fed him with lies, he has believed it, thinking that is credible. But if in the end it is proven to be not true, that means he still has needs to do what? To look for evidence. What he thought has been established has not been established. So that alone hasn't given us any particular leadway, any particular lead into what woman. So I want to narrow it down, talk about the generally acceptable definition, and then finally I'll round it up with my own definition of the term evidence. So I want to talk about that of Phipson. Phipson defines evidence to mean the testimony, whether oral, written, or real, which may be legally received in order to prove or disprove some facts in dispute. So his definition is akin to the definition of Aguda. But the difference here is that he never excluded inferences. He didn't exclude inferences. So, and that is why we think his definition is far better than that of Aguda. But the problem that has made modern scholars in this area to start thinking further is the issue of fact in issue. When we talk about fact in issue, we're talking about those facts that make up a particular matter. We may have so much amalgamation of facts running to hundreds of facts. Doesn't mean that in every time we need to prove a fact in issue, all these things must come in. So to that effect, therefore, I have made my own contribution to the definition of the word evidence. And I've said that it is the testimony adduced by a party to a proceeding or his witness, which may be oral, documentary, or real, with the intention of persuading the court to believe in its credibility and with a view to proving or disproving the issue in dispute. Now, the question you may want to ask me, what have I contributed to knowledge in this discourse? Now, what I have contributed to knowledge in this discourse is one. When you talk about evidence, it doesn't only come forth from the party in the proceeding. It also comes forth from who? The witnesses he has called. So my definition has try to take care of that very angle. And then again, I have also fused the types of evidence that get used in line with Aguda and Phipson's own contribution. And I have said that every evidence has the purpose, the underlying purpose, to try to persuade the court to believe that what you're saying is true. And the final end of this journey is to prove what? The issue in dispute, not a fact in issue. Why? Because if you talk about a fact in issue, there are several facts that can be an issue, and those facts that are an issue are not the exclusive reserve of the claimant or plaintiff or even the defendant as far as onus or burden of proof is concerned. Why? Because the major onus of proof targets the person that we lose in the end if no other evidence is adduced. Therefore, when you talk about onus of proof, burden of proof, you are looking at the final product. So if we introduce fact in issue, remember there's something called evidential burden, which shifts from one person to the other. Therefore, that's why I remove the word fact in issue to introduce the dispute in issue. Because the essence of evidence is to do what? Is to make sure that your case is proved, or for the opponent that he has disproved your case. So from here now we'll look at sources of the law of evidence in Nigeria. So I will quickly discuss this. Normally the first port of call is the constitution as the ground norm of the country, constitution as the highest law of the land, has created in the legislative list the arm of the legislative body that has the legislative powers to legislate on evidence, which means evidence is in the exclusive legislative list. So the birth of evidence, the recognition of evidence, first of all, can be traced to where? The Constitution. So to that effect, therefore, the Constitution becomes the major source, the original source of the law of evidence. And then after that, we can talk about the principal law. The principal law of evidence is law of evidence itself. The law of evidence is all about evidence. It doesn't talk about any other thing apart from evidence, how to prove a fact, disprove a fact, and all that it contains. And then we can also talk about other legislations and subsidiary legislations. Other legislations are not principally concerned with the issue of evidence per se. But once in a while, somewhere in between, they will just mention evidence. For instance, let's talk about Company and Allied Matters Act, CAMA 2022. In that act, you discover that there are other provisions talking about companies, incorporated trustees, and so on and so forth. But within the body of this law, they will tell you how to register a company, how to show that you have registered a company through your certificate of incorporation. What is it talking about? Evidence. That certificate of registration is prima facie evidence that the company has been incorporated. Then every other law we can think of, there must be element of law. There must be element that pertains to evidence in every law that you can ever think of. The same thing applies to customary law. Customary law, just like the English law, common law, is equally about evidence and other things. And then, in our native jurisprudence, we have means of proving things, even in Islamic law. The one that tells you this particular fact can be proven only by more than two witnesses or more than a witness. So when a law talks like that, it's talking about what? Evidence. If your custom says somebody that had committed an offense, if the person was not caught red-handed, the best way to find out is trial by ordeal. What is he talking about? Evidence. Because the essence of trial by ordeal is to find evidence that will lead them to the root of the matter, so that in the end everything is what is determined. So we can also talk about the received English law, at least as far as it is concerned, and for whatever it is worth, because we are going to talk further on that. Now, after the sources, we're going to talk about the scope of the law of evidence. In scope of the law of evidence, when you look at the definitions we have already discussed, you will see the scope there. Talking about oral evidence, documentary evidence, real evidence, these are the major scope when we talk about this, the wide range of evidence, and so that every other aspect must find a way to join in any of these three arms. So that's talking about the scope. And then I also want to talk about the historical background. How did we come by this evidence we are talking about? Especially the English type of evidence that we're practicing today. So before the advent of colonialism, we know that we as Africans, we had our original method of resolving dispute. We have our original method of finding things. Maybe go to find it through Juju. When somebody hears that name, Juju, you're asked to swear. The person will start telling you the truth immediately. So it was effective as far as it lasted. Now, during the taking over of the African countries by colonial masters, they began to introduce their own laws, right? And then when the colonial masters took over Nigeria, there was naturally no evidence act per se. Our law of evidence was basically the common law as was practiced in England, not until 1945. It was in the 1945 that this ordinance that was called out of the Stevens Digest 12th edition was put into place and started put into operation in Nigeria, that we for the first time tested what is known as a body of law on evidence. So from then on, we had series of acts like we had the 1990 Act, we had the 2004 Act, and then now the 2011. This is the brief history of the law of evidence. And why do we keep changing? It's because none of them, those past laws, was comprehensive enough to satisfy our needs, just like the definitions that we have looked at. Maybe tomorrow somebody will also come out with a definition that is more elaborate. So that is talking about the historical background. And then one may want to ask, finally, and so because I will conclude at this point, you might want to ask, we are said to have received the English law, common law, and equity. What is the position of common law rules on evidence in Nigeria today? Now, I want to go back memory line a little bit. There was a time under the 1990 Act, precisely, we had a Section 3. Section 3 of the Evidence Act, which we call the importation section. Why? Because that provision empowered Nigerian courts to bring in things from the English jurisprudence that are not contained within our Evidence Act. In other words, it was a provision that empowered the court to look back and then apply the rules of the common law rules of England. Now, under the 2004 Evidence Act, we had Section 5A, which was a replacement of Section 3. Section 5A was an omnibus clause, an omnibus provision that allowed the courts to fill in the lacuna or lacunae in terms of where we did not have provisions covering some certain things. Under that Section 5A, we can then import the practices that is done in England under the common law rules. But the interesting thing now is that when you look at sections 1, 2, 3 of the New Evidence Act 2011, it is a no-go area. This New Evidence Act has said no more. We are no more importing the rules, common law rules of England as far as our Evidence Act is concerned, just as if our Evidence Act is comprehensive. So, but that is the position of the law as of today. So, common law rules of England has no space, has no place in our legal jurisprudence today as far as the law of evidence is concerned. So maybe by the time we start looking at other topics, those who want to tell us this is a register, which is a common law doctrine, this is similar fact evidence, which is a common law doctrine, this alone will disprove you to tell you that we can no longer import those common law rules under our Evidence Act because they are what outlawed. They have been blocked. There's no way we can use them again. Our law doesn't permit them.